Good morning, friends. You have seen innovation in the program itself. Ganpat has started innovating by promoting the last speaker in the middle chair. So he innovated, taking the advantage of he said he is my student. Of course, he is not my student in that general sense, but I have the pleasure to say that I am his teacher. Friends, there are two communities which harmonize the development and progress. One community is called scientist community, those who are inventing, innovating. Those are called scientists and technologists. So if you have more scientists and more technologists, obviously your invention in innovation would be more. And if you have lawyers or worth the salt, not like me, worth the salt like Prabuddha, worth the salt lawyers, they will design the right. Mind it, about 50 years back, I must have been a student of intellectual property about 60 years back, when it was called as industrial property, not intellectual property. It was called industrial property. And very interestingly, it was not called industrial property, it was called industrial property right. Not industrial property, because you must distinguish between property and property right. That's what Ganpat has already started. We lawyers design right. Say for example, lawyers who designed limited liability. Had this design of limited liability not been invented at that time by these lawyers, whole industrial civilization would not have been possible. You can't have good big companies with thousands and $billion dollars. You could not have that. So you required a kind of a proper design, legal design. That's why lawyers are needed. So these two communities, they now have to mix, join hand together. We started intellectual property right education in 1995, maybe a bit early 1993, but then we are limping. 1995 it took a kind of a jerk in National Law School, and I had my young team. Since I was the only person or professor of that rank at that time, I had to design those with my young team. And we all talked about what? Designing what? Designing right. Because it is not property. Intellectual property is not a property. If it is a property, it is right in rem, is right in fact, right in rem, right against the whole world. As soon as I say it is a property. It does not require any other right, because all the rights are bundled in the concept of property. And there is one right which is extremely provocative. It's called residuary right. Who has the residuary right? An element of right is left over there. If I give all the rights to you, still some right would be belonging to the owner. Right? So this residuary right is extremely provocative and important. And state used to have this residuary right in the form of eminent domain. So this is property. But we have an essential conflict, calling this intellectual property as also a property of an individual, giving that individual as a right in rem. Why? It is because that individual, when he is taking shape, he is inventing. Mind it, he is inventing. He is using his brain. He is inventing. And then, of course, some business people will commercialize. If there is no invention, there will be no commercialization. So he is inventing. When he is inventing, he has hypothesis, he has experimentation, and he has tests. And he invented as a scientist. I don't know why Newton did not call for patent. It was Marconi who wanted for patent. So it seems fundamental science, which generates these inventions and innovations, I warn all of you, is drying up. I warn all of you that that fundamental science is drying up. I have seen across the whole country. I moved from university to university. It is so pathetic that the third grade students are coming to physics. At one point of time when we were young, our first choice was physics. Not even engineering, physics. Physics, chemistry, that was our choice. Now those who are of my age, I think I am the senior most here. You have not entered into 70s. I am now running 73, so I am perhaps the senior most here. During our age, when we were young, we were energetic in two subjects. We have visions were physics or economics. Now in your age also, some of you must have seen, those who are in late 50s and 60s, you will find that your main aim was engineering, not technology. Now, those who are in 40s and 50s, late 40s and 50s, their main aim was technology, not engineering. And the next batch comes, they are more interested in management, not even technology. Now, fundamental origination, those who will tell us that I have invented, we require those. Who are they? They are the scientists. I have so pathetic conditions in the country. Yesterday, if you look at the newspaper, you will find Government of India has advertised asking for scientists to be recruited. And you understand what is the salary? Salary is 13,000. Tell me, you are appointing a scientist having the master's degree and PhD. First class master's degree and PhD. Now you are giving 13,000 rupees. Why? Because human resources are cheap here. This is not the way. Industry has to come to the university. I am now facing a lot of challenges from the Supreme Court are asking some of us to prepare a kind of a design as to which can be the deemed university. And we understand that all the deemed universities which are called, given in the last about 50 years, 146 deemed universities, they do not have any research facility, any worth the salt. And we are talking about green technology. Green. Unless the fundamental research is there, there is no, my friend, no green technology. It is the fundamental research. And that fundamental research you are giving 13,000? Government cannot give, I understand. Where are the private industries who want to reach through the intellectual property right and asking the lawyers to design the right? We'll certainly design rights. We'll certainly design rights. We'll try to make the eminent domain very minimal and give you maximum private rights called in personam, right in personam. We'll create right in personam. We'll also create right in delictu. Like say copyright. Copyright violation is an offense. Now, Britishers made trademark violation is an offense in the Indian Penal Code. In the Indian Penal Code, you open it, there is a chapter on trademark right violation. Why? Because that right, if it is a criminal law, then it is right in rem. I can go anywhere and seize. Patent right is not right in rem, it is right in personam. It is not a criminal law yet. It is not a criminal law yet. If there is a patent law violation, it is right in personam. Suppose you find that a software is not, supposing software is not copyrighted, supposing, and it is only patented, and I have a software, violated software in my house, you cannot do anything to me because I have bought it from him. You can go and arrest him, not me. Not arrest, file compensation case against him, not me. It is not a right in rem. But since it is copyrighted, anywhere this violated, pirated, copyrighted materials are there, you can straight away go over there, seize. There has to be a seizure, there has to be a punishment, there has to be a penalty. All those are available. So you have 7 types of, the rainbow of rights that we have created, 7 types of rights we have created, and you will be speaking about all those in the next about several sessions. And this session has to complete by 10:45, and I have speakers also left out. That's why, interesting though, I could have said, how do you design right? How do you design right? What right and corresponding to what duty? If there is a right, there must be a duty. What right and to whom the duty lies? We could have designed that, but maybe we'll design in some course of time, not now in this inaugural session. But in the inaugural session, it is always good to remember that inventions and innovations are in the universities, still in the universities. What is your role in the universities? Where are you in the universities? Even I do not find, at one point of time, Mashalkar used to say, he was one of my participants in some of the courses that I ran earlier in 1995. He used to say, Professor Mitra said, that if he has a small atom bomb, he will drop on the patent office. And he was very angry on that day when I told him. But ultimately he repeated this word several times. Of course, now our patent office has come a long way. It is now good. It is now world standard. But still, I feel so pity when a person who is in electronics is asked to examine some biotechnology material. When we are going to solve that specialization which he was telling me, I asked him, what you are? He said, you are not specialized. I am specialized in patent. Then further he said, I am specialized in electronic patents, he said. That is what is specialization in the US and what is where we are.